Welcome back, everyone. I'm Jack Shelton, a lawyer at Aegis Space Law, and I'm here to answer your space law FAQs. So a follower from Singapore asked the following question. We want to invest in a U.S. space company by purchasing stock. We will purchase less than 10% of the outstanding voting stock. Do we avoid CFIUS jurisdiction by staying under this 10% threshold? Well, the short answer is not necessarily. We actually don't have enough information to answer this question. Here's the long answer. CFIUS is an acronym that stands for the Committee on Foreign Investments in the United States. CFIUS has jurisdiction to review certain transactions between foreign persons and U.S. businesses. If CFIUS has jurisdiction, and if they believe that the transaction presents a national security threat, then they can recommend that the president order the transaction to be blocked or unwound. In those instances, CFIUS can also force companies to enter into a national security agreement, which is incredibly expensive and burdensome. In some instances, when CFIUS has jurisdiction, companies have an obligation to disclose the transaction to CFIUS before it occurs, and that process can also be an expensive and time-consuming one. So companies often try to avoid CFIUS jurisdiction outright, and we often consult with our clients to help them structure transactions to avoid CFIUS jurisdiction. Now back to the question. So there seems to be this misconception floating around that if a foreign investment involves less than a 10% stake in a U.S. company, then across the board CFIUS jurisdiction is avoided entirely. And this isn't true. There are two major paths by which CFIUS can claim jurisdiction, and this 10% threshold is relevant to only one of those paths, and it still isn't the only factor to consider. CFIUS can claim jurisdiction if they determine that the transaction is either a covered control transaction or a covered investment. I'll explain how both of these are defined, but first I'll point out that this 10% threshold is only relevant to covered control transactions. It is not at all relevant to whether the transaction is considered to be a covered investment. A covered control transaction is defined at 31 CFR 800.210, with further explanation at 31 CFR 800.301 and .302. In short, a covered control transaction is any transaction that could result in foreign control of a U.S. business. Control is defined quite broadly in the CFIUS regulations at 31 CFR 800.208. And in short, it means the power to determine important matters affecting an entity through the ownership of a majority of the total outstanding voting interest, the ownership of a dominant minority of the total outstanding voting interest, board representation, proxy voting, a special share, contractual arrangements, formal or informal arrangements to act in concert, or other means. So obviously that's quite broad. Often what we'll see is a foreign investor will invest in a company in exchange for, let's say, an 8% stake in the company. And the investor doesn't take a board seat or have any of the other indicia of control on that list, except there's this question as to whether an 8% stake could be considered either a dominant minority or one of those other means by which CFIUS could determine that there is control. Fortunately, there's a provision at 31 CFR 800.302b, which provides a sort of safe harbor. And it says that if the investment is purely passive, and if it results in the foreign person holding 10% or less of the outstanding voting interest in the U.S. business, then this will not be considered a covered control transaction. So this seems to be directed at that dominant minority and the other means factors which could result in control. So back to that original question. The person who asked this question told us that their investment will result in a foreign company owning less than 10% of the outstanding voting stock. But they didn't tell us whether they're entitled to a board seat, whether they will have a proxy vote, or any of those other things that will help us determine whether there are indicia of control. Furthermore, even if we could determine that the transaction doesn't constitute a covered control transaction, it still might constitute a covered investment, which is a completely different analysis, and there is no 10% safe harbor under that analysis. So, long story short, the mere fact that this foreign investor is taking less than 10% of the voting stock is only one small piece of the puzzle. It's not nearly enough information for us to make a determination as to whether CFIUS has jurisdiction. All right, that's it for this week's question. If you'd like to submit your questions for us to answer, just click the link in the comments below. And if you otherwise would like to chat with us, please reach out. at hello@aegis.law and let us know that you saw this video.